Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. Sitting in for Pinky Webb, I'm Mai Rodriguez. Today on the program,
the Philippines is a sovereign nation until those questions of jurisdiction and the effects on the sovereignty of the Republic are sufficiently answered. I cannot cooperate with them.
the Philippines maintains its position in its latest appeal to the International Criminal Court, urging the body to suspend the war on drugs probe. The Office of the Solicitor General also tells the ICC not to rush the Philippine government in its judicial processes.
There's somebody else that we can clearly point to, and he can be held accountable for that with his public speeches and very fiery statements.
But for the camp of the families of the drug war victims, the recent Philippine government appeal is nothing short of a rehash. Solicitor General Menardo Guevarra joins us live. The Philippine government appeals to the International Criminal Court to suspend the investigation into the drug war killing under the administration of former President Rodrigo Duterte. A lawyer, however, argues that the plea is a rehash of what it has presented before the pre-trial chamber. Let's go straight to the source of the story, Solicitor General Menardo Guevarra. Good morning, Solgen.
Good morning, Mai, and good morning to everyone.
It's good to have you here, sir. First of all, this appeal to the ICC to suspend the drug war probe, do you think you provided enough basis for the ICC to rule in your favor? Because lawyers of the victims' families say it's just a rehash of the government's previous arguments.
Mai, that is not exactly correct. You know, we have been submitting all the necessary information and data requested by the ICC prosecutor in the past. But it seems that no matter how much information or data we give the ICC, we feel that they're bent really on concluding, in their conclusion, that what we're doing here is not enough. So when we filed our appeal brief, we shifted our strategy. And instead of focusing on previous arguments about the sufficiency of our domestic investigations, we focused on the legal errors committed by the pretrial chamber. And most notable of these errors is the fact that they exercise jurisdiction at a time when we are no longer a member of the Rome Statute or the ICC. And there are other legal arguments, assignment of errors that we have not argued in the past.
Okay, that explains why the need to shift your strategy.
Definitely, yes.
Okay. There is a statement in the appeal that those to be held accountable are low-ranking or mid-level police officers. The NUPL, National Union of People's Lawyers, found it chilling and completely false.
Mai, that is only for a start. Normally, when we apply the usual investigative processes in our country, we start with people who were actually in the scene of the crime. And those people have actually been identified. So we start with them. We cannot start with, let's say, a PNP superintendent who was not even there at the scene of the crime. So we are trying to build cases against other officials. But we've got to start from people who are or who were on the ground when this thing happened. So we're hoping that in their defense, they will provide certain information that would probably lead us to an investigation of other people concerned or involved. Maybe some superintendents or some, in the military higher-ups or police higher-ups who might have given them the necessary order in connection with the campaign, in connection with a particular incident. So that's what we're trying to do.
Looking back, when the ICC Office of the Prosecutor looked closely on the Philippine investigations, the reports that were filed, they found it insufficient, and they said it didn't completely show the entirety of what happened in the war on drugs.
Yes, Mai, that's what they're saying, and we clearly explained in our appeal brief that the threshold or the standards that were applied by the ICC pretrial chamber were incorrect, in the sense that you see, under the Rome Statute, there are two very important provisions pertaining to the admissibility of a case. Admissibility means whether they will accept or admit the case for investigation. Because if it's already being investigated domestically, then the ICC will not admit it anymore. So Article 18 is about a preliminary assessment only, admissibility challenge. It's on a preliminary basis, and it's a general Philippine situation that is being looked into or being assessed. Article 19 pertains to admissibility challenge of a concrete case, meaning a person has already been indicted, identified, investigated, and now being prosecuted. Now, the ICC applied the standards for Article 19, which are very high, the standards, for its Article 18 preliminary assessment of the Philippine situation. So we're saying that you are applying the incorrect standards for your evaluation, and for that reason, you failed to appreciate fully the information that we have given to show that the general situation in the Philippines is that we are conducting the appropriate investigation. You applied a different standard, a higher standard, applicable to a concrete case where a person is actually being indicted and investigated already. That's one of our major assignments.
And you're saying this is only a preliminary investigation?
Yes, exactly, under Article 18.
Let's go to some of the points that you raised in your appeal. First, the probe lacks a legal foundation and encroaches on Philippine sovereignty. But looking back, the country ended its ties with the ICC in 2018. It took effect in March 17, 2019. And prosecutor Karim Khan said the court still has jurisdiction on the alleged crimes committed from November 2011 to March 16, 2019. So how do you reconcile this?
That is another assignment of error that we included in our appeal brief. We argued that it is not enough for the ICC to claim that for as long as a crime was committed within the period during which the the Philippines was still a member, the ICC would have automatic jurisdiction over the investigation of that case or that incident. We're saying that that is wrong, that is incorrect, because jurisdiction should be determined at the time that it will be exercised by the ICC. And when did that happen? That exercise of jurisdiction by the ICC occurred when the ICC prosecutor asked for authorization to commence his investigation. That is the only time when the exercise of jurisdiction by the ICC was called. And when was that? That was in September of 2021. Now, at that time, our withdrawal from the Rome Statute or the ICC had already become effective because it became effective in March of 2019.
Okay.
So that's our main argument there.
Let's go to another point in your appeal. It's that the ICC probe would adversely affect its mandate due to the implications such acts would have for those affected by the court's operations, in particular, suspects, witnesses, and victims. Do you mean that the probe would slow down court proceedings?
No, that is not what we meant, Mai. What we're saying here is it will not be good for the ICC as well to proceed with an investigation if its very jurisdiction over the state is in question. So, for example, the appeals chamber has not even made its judgment on the appeal. No resolution yet. But the ICC prosecutor is allowed in the meantime to continue its investigation. So what does that make? What is the meaning of that situation? Ibig sabihin noon ay we're not even sure if you have jurisdiction, but you're already conducting the investigation. Here, you're causing a lot of inconvenience. you are maybe in a way harassing certain individuals, but your very jurisdiction has not been clearly established. So what the President said is, you cannot expect any cooperation from us for as long as this issue of jurisdiction and admissibility has not been settled with any clarity or finality.
Sa tingin niyo ho ba, minamadali kayo o pinipressure kayo ng ICC with these drug war investigations?
Hindi naman kami sa minamadali, pero ang effect kasi noon ay parang yung conclusion nila ay unfounded. No? Yun lang naman ang sinasabi namin dyan. Kahit naman madaliin nyo kami, ito yung proseso namin, kailangan naming sundin yan. So, in a way, parang ganon. No? Pero ang gusto lang namin sabihin is, intindihin nyo na ganito ang aming process. No? We give due process. Justice is served not only for the victims, but also for the respondents. Because why will you charge them if the evidence is not sufficient against them? They are entitled to due process. Kaya yung proseso na yon takes a little time. And that's what we want the ICC to understand. Justice is not served on one sector of the population alone.
Yes.
Justice is served to everyone.
But then there is this thing that justice here is very, very slow. Also, in the how many cases that were filed because of the drug war killings, ilan po ba yung na-prosecute at na-convict?
Let me explain that. No, it's a good thing that you asked me that question, mine. No? Kasi the figure of 6,000 plus cases has often been mentioned. No, yun yung mga yun yung number of deaths that had been, kumbaga parang admitted even by the Philippine government. No, but it doesn't necessarily mean na yung 6,000 plus cases na yon ay puro may kinalaman or may lapses ang ating law enforcement agents. Yan ay initially investigated by the PNP Internal Affairs Service. At by and large, the majority, from their point of view, ay nakita naman nila that the proper protocols and procedures were followed. Except for several na sinubmit nila to the DOJ, in which we endorse naman to the NBI for case build-up. So, lahat naman yan natingnan. Kaya lamang, yung iba, ang general conclusion ng PNP, okay naman ito Pero itong mga kasong ito, kailangan ito talaga maimbestigahan. So, yun yung inuna ng Department of Justice. So, one more point, no, and I have mentioned this many times before, we also expect the families of the victims to come forward, to cooperate, to show some interest. Kasi ang experience namin, a large number ay hindi nagpapakita ng interest, not cooperating with the law enforcement agencies. Kung natatakot sila, I have already said many times na the Department of Justice has its witness protection program. Also, the Public Attorney's Office is there to help them in preparing yung kanilang mga affidavits, their complaints, etc. And to get the supporting evidence, no, to support their complaint. So all of these mechanisms are in place. But quite sadly, we're rather frustrated by the lack of interest on the part of many, not all, but many, of the families of the alleged victims ng abuses in the war on drugs.
But of the figure that you mentioned, the state figures say it's more than 6,000
Yes.
deaths. But ang sabi po ng human rights groups, the number is at 30,000 if you would include the vigilante-style killings.
Well, I cannot really comment on that, no, because I don't know where these people are drawing their statistics from, no. I don't know whether they have figures to show that or that's a mere extrapolation on their part. But you mentioned the vigilante groups, no. It's not as if no investigation was conducted, no, in connection with vigilante groups, more particularly those which have been claimed to be operating in the Davao region. Marami nang nag-conduct ng ng investigations diyan, including our own Commission on Human Rights, no, our own CHR, even Congress. Pero in the end, what did they find out? Wala naman talagang sufficient evidence to show the existence of a death squad, so to speak, no? Yan naman tiningnan eh. Pero ang finding ganun din, na walang enough evidence to show.
Right. We will have lots of things more to talk about. But we have to take a short break. This is The Source on CNN Philippines. Stay tuned. You're watching The Source on CNN Philippines. I'm Maya Rodriguez. Our source today, Solicitor General Menardo Guevarra. Soljan, let's talk about what happened in the drug war killings. Do you personally believe that extrajudicial killings happened or were committed under the Duterte administration? And do you believe that this is tantamount to crimes against humanity?
Definitely, I believe, Mai, that there were abuses in the conduct of the war on drugs. No? Alam naman natin yan because I myself reported that to the UN Commission, rather Human Rights Council, sometime I think in 2018. No? And that's documented because the DOJ, when I was still the secretary, conducted a very limited, however, a very limited investigation of the war on drugs. Limited in the sense that the number of cases that we saw was not large because it was the pandemic. No? It was the time of the pandemic. And we were limited by certain mobility constraints. So, but at least in those areas na tiningnan namin, no, those areas where rampant ang alleged EJKs or summary killings, we made certain findings there, and I reported that. No? Certain lapses on the part of law enforcement agents. So I admit na meron talagang abuses, and that's what we're trying to address. But I am saying that that is not tantamount to a crime against humanity because the war on drugs was a legitimate law enforcement operation. It was the target of that war on drugs is to stop a crime, to stop the proliferation of illegal drugs. Hindi siya targeted to eliminate a particular segment of the population, which is the definition of war or of a crime against humanity. That is not the purpose of the war on drugs. It was only incidental that in the course of executing a legitimate law enforcement operation, many people were killed. But that does not make it a crime against humanity.
Pero I think, Soljan, ang pinupunto ng mga human rights groups at yung mga pamilya ng mga biktima is someone should be held accountable for these crimes, and that someone should be higher up. Hindi po yung dapat mga low-ranking and mid-level police officers. Kasi po, ang sabi po nila, ultimately, it was President Duterte who created a culture of impunity. Dati po yung mga pronouncements po niya, di ba? Ang sabi po niya, kill, kill, kill. And early on, in his administration, he promised blood. There will be blood, sabi po niya.
Yeah, right. But you know, I have also explained this several times in the past, that when we judge the former president, President Duterte, we have to take into account everything that he said about the war on drugs. We cannot be selective in what he said. So it's not appropriate, it's not fair that you pick a certain statement that he made on a particular occasion, but totally disregard other statements that he made on other occasions. Because I personally heard and saw the president, the former president, making an explanation about his own statements regarding the war on drugs. He clearly stated that when he made statements like that, well, of course, spiced with a lot of bravado. He's known, you know, for making a lot of hyperbolic statements. He actually meant to use the necessary force only when the personal safety or security of the police officer is in jeopardy. In other words, you use reasonable force if you yourself are in danger of being killed. So he made that statement many times also. So we balance everything. And what he said on one occasion, he tempered on another occasion.
Soljan, I'd like to talk about what's next after the appeal and the strategy that the Philippine government is taking. You have hired, the Philippine government has hired an international lawyer. Can we know more about her? I think she is an expert in international criminal law and human rights law. Are we paying her for her services?
Yes, Mai, definitely. You know, the Office of the Solicitor General would, on many occasions, need the assistance of foreign counsel. For example, in international arbitration cases, where certain procedures and need for evidence might be something unique or special, and not for which we are not very familiar. So,
Can you name her, sir?
all right. In this particular case of the ICC, we engage Miss Sarah Bafadel. She is a British barrister, but she has her chambers in London, but she's practicing at the ICC at The Hague, the Netherlands. So international criminal law is her field of expertise. And we chose her from a list supplied to us by the Philippine Embassy at The Hague. And we found, based on her training and experience, that she would be the best international criminal law expert who might be able to assist the Philippine government on procedural issues, essentially.
How would the Philippine government justify hiring the best legal defense for the previous administration and, in effect, to defend President Duterte?
I am happy that you asked that question, because I want to clarify to our listeners here, to the viewers here, that the OSG is not representing any particular individual. The OSG is not defending any specific person. The OSG is representing the Republic of the Philippines. We are representing the state. And we are saying that we are defending our domestic legal and judicial system because it has the primary responsibility to deal with crimes that were committed in our own territory. So for that purpose of defending our legal system, the primary right of our system to take care of this matter, we may need the assistance of foreign experts because the venue is not a local court, it's the International Criminal Court. So for that reason, since it's the state which is the client or the principal of the OSG, then necessarily the state will also have to share in the cost of the service, legal service, being fairly extended to us by a foreign expert or consultant.
Okay, we'd also talk about the independent commission being proposed for the drug war killings, but we have to take a short break. This is The Source on CNN Philippines. Stay tuned, please. You're watching The Source on CNN Philippines. I'm Mai Rodriguez. Our source today, Solicitor General Menardo Guevarra. So, Jen, I'd like to talk about the independent commission that you proposed to investigate the war on drugs cases. At this stage, ang sabi po ni Justice Secretary Boying Remulla, he doesn't agree with it.
Well, the idea is still percolating. No? It's an idea that has been floated several times in the past, not necessarily from me alone. There were other very important persons who broached or floated the idea. So last year I submitted, early on, during the administration of President Marcos Jr., I submitted a memorandum about this whole idea. And I guess the President has to consult other persons regarding this matter, because this is quite sensitive also. So that's where it is right now. People are giving their comments on the advantages or disadvantages of such an idea. But I think from my point of view, it's a good one because it will complement the existing investigation being done domestically.
Okay.
It will probably expedite. So yung mga hindi natatawag na higher ups siguro, dahil nga we're starting from below, maybe those other higher up or higher officials may be called by such an independent commission if it's created.
So then let's talk about possible scenarios. Should the ICC push through with a probe, what will happen now? Will the ICC be allowed to enter the Philippines even without government cooperation? And do you see the possibility of arrests of prosecutors because there were threats before?
No, I don't think so, if they want to conduct their investigation here, especially if they're allowed by the appeals chamber, then so be it. For as long as they don't commit any offense here in our territory, then they will not be arrested. Coming here and doing an investigation is not an offense. All right. So, but whether or not the Philippine government will cooperate, that's another matter. So anyway, the ICC can do its investigation, whether by coming here or by conducting it outside the country. They're free to do so. So they have so many avenues or options on how to go about conducting their own investigation.
Okay, let's talk about the ICC's arrest warrant for Russian President Vladimir Putin. Analysts are saying this is a shadow of things to come for former President Duterte. So what do you think? If the ICC issues a warrant for the former president, do you think, is this enforceable?
Well, the matter of issuing a warrant of arrest is always a possibility once the investigation is commenced. So if the appeals chamber authorizes the prosecutor, despite our appeal, to conduct his investigation, then part of that investigation is the issuance of a warrant of arrest. Now, whether the ICC can enforce it or not is a totally different question, because the ICC will have to depend on local authorities to enforce that warrant of arrest. So if the government does not cooperate because the matter of jurisdiction has not been finally settled, who will enforce the warrant of arrest?
Right. I think that's one of the biggest challenges for the ICC in the past 18 years of prosecuting cases. Thank you so much for your time this morning, Solicitor General Menardo Guevarra.
Thank you, Mai, and thank you, everyone.
Thank you for joining us here on The Source. I'm Mai Rodriguez. You're watching CNN Philippines.